In a few weeks, the Presidential Election Petitions Tribunal will deliver judgment in the suit challenging President Bola Tinubu's victory in the February 2023 presidential election. Likewise, some state election petitions tribunal have started giving judgments, while others are on the verge of delivering theirs. However, some state election petitions tribunal have started giving judgments. For those who have started, for those who have been following proceedings at the Lagos State Governorship Election Petition Tribunal, would have seen the scenarios that are playing out where the two leading political parties, APC and the Labour Party, at the March 18, 2023 governorship election, are working tirelessly to cancel each other out. The interesting thing with the petitions before the tribunal, however, is that while the APC and Labour parties argue against each other over candidacy qualifications, none of either the APC or Labour Party sees anything wrong in Jandor PDP candidacy and his qualifications, as there's nothing in their responses to PDP petition that suggests that. Joining us now on the morning show as we take a look at the Election Petition Tribunal and their proceedings is Liborous Oshoma, a lawyer, and Ahmed Buhari, a public affairs analyst and vice presidential candidate, African Democratic Congress ADC in the 2023 election. Welcome to the show.
Thank you.
All right, I'll start with you, Mr. Oshoma, because you've been here with us even during the election itself. And we've seen the tribunals play out. I'm sure you've monitored some states. What's your general overview? Again, against the backdrop of all eyes on the judiciary, how well, I don't know if you're the best person to ask, a lawyer yourself, has this been conducted in terms of the judiciary?
Yeah, all eyes on the judiciary first and foremost. Just that here we overflog issues, very sentimental. Naturally, like Lord Dennis said, when a judge sits on trial, the judge is on trial. And so when you're trying a matter, the entire world is trying you. And so it's this, there's nothing out of the ordinary when people say all eyes on the judiciary. You know, but just that we're very sentimental about it, and it now becomes as if there's something, you know. But also the attitude, the situation where you now try to, you know, what you call mob lynch, online lynching of a particular, you know, organ of government. That's what I frown about. But there's nothing wrong with, you know, fixing your eye on what's actually happening around you. But that said, also against the backdrop of my knowledge and experience at election petition tribunals, I've handled quite a lot since 2003. Proving election irregularities is usually very difficult. It's a very tall order because consistently the Supreme Court has said that you need to prove polling unit by polling unit. And it must be the agents of the party that witnessed what transpired at the polling unit. And if you're talking about collation, then it must be your agent at the collation center. So what most of these candidates do, or most what the petitioners do, they know that that area is a tall order. So they look out for the technical areas, qualification, of candidates. And so most of the judgment that had been delivered, starting from the one in Delta, you know, dwells on qualification of candidate. And because also the court has said that qualification is both a pre-election and post-election issues. And so you find out that, so what petitioners do, they don't want to bother themselves with all of those tall orders of having to prove irregularity polling unit by polling unit, because it becomes a very difficult one. So they look out for, you know, is this candidate qualified, where the primaries validly, you know, conducted by people who should conduct the primaries, and at the qualification, at the certificates tendered by the candidates, you know, are they, you know, verified, and where the certificate forged. So those are the issues they all look out for, because those ones are easy for you to prove. And one issue that consistently, even in the Lagos State Election Petition Tribunal, is that issue of qualification and membership of a political party. And so you see that, a recurrent decima in most of the election tribunals, especially given the fact that, you had a new wind, a new kid on the block, that's the Labour Party. And so there were a lot of contentions that by virtue of Section 77 or so of the Electoral Act, not belonging to a political party 30 days before the election, that's, was a ground for disqualification. So these are most of the issues that, keep recurring, and then in all of those things. Therefore, Lagos State, the issue, there was a contention also on the validity of the Nigerianness of the deputy governor. All of these are what the court will eventually rule on.
Okay, so I'll come to you first, Ahmed. In terms of what you see from how the election in Lagos State has gone and what you see in terms of what is happening in the tribunal at the moment, one of the things that's been raised, yes, qualification and issues of membership of the political party. I don't know why this is almost consistent, and it happens almost all the time with almost every election. Is this an INEC issue? Should INEC be held to account when it comes to issues like this? And then secondly, when we have election petition tribunal issues and the parties involved, especially when you have this kind of tripartite issue like APC, PDP, and Labour, should there be a kind of merger arrangement that means that 2 against 1, or should they still be all the 3 parties competing in the courts, and what do we expect to be the outcome of this? Is this going to be a case of Lagos State will have APC and Labour disqualified and automatically it goes to PDP? Is that a possibility?
Thank you for having me. Yes, it's a possibility. Anything can happen, and clearly from what Liborous Oshoma just stated out in the studio in Lagos, it's obvious that there's been cases around qualification and sponsorship of candidates in political parties. And you did ask me if this is a Nigerian issue or if it's an INEC issue. I think it's an INEC issue in the sense that it needs to validate these documents before it tenders it as valid documents, number one. Number two, it's a party issue. Political parties should not be in too much of a hurry to tender these documents without making sure that their aspirants are qualified to actually contest in primaries, because at the end of the day, you need a sponsor that is going to put you out there to contest for a general election. And then thirdly, it's a Nigerian problem. I think this is a wake-up call to all of us, from politicians to people who have been inducted as ministers today, to ensure that every single step of the way you ensure that your documents are correct, from the names you use to how you use the names, because whether we like it or not, some of those names do look like they've been forged. We've seen the case of Delta State, where clearly the House of Rep member, Honorable Ngozi, has been actually disqualified by the tribunal on the grounds that he is not a member of the political party, Labour Party. It means that whether we want to look at it from any angle, if his name does not appear on the membership register of the Labour Party in Delta State, indeed, there is a problem. Similarly, I was going through documents from the Lagos State Tribunal, and I think the Jando PDP angle of the conversation at the tribunal did present certified true copies of the Labour Party's membership register, and clearly the name of the man who stood in favor of the Labour Party that was sponsored by the Labour Party, his name didn't appear on the register. So for many members of the Labour Party, they have been having this conversation, and they say it's a pre-election matter and it cannot be discussed. But Section 177C of the 1999 Constitution of the Federal Republic of Nigeria, as amended, requires that you must be a member of a political party to contest or to be sponsored by that political party. Similarly, in Kano State, you cannot rule out Honorable Afis Bayero of the APC, who sent to courts, who took to the tribunal the NNPP candidates, on the honorable who won in NNPP, and said clearly that he has discrepancies in his certificates. And on that ground, the tribunal has actually sacked the NNPP candidates. And is the same thing that the PDP is also presenting in Lagos State with regards to Governor Sanwo-Olu, who INEC was subpoenaed to come to the court to present the results that Governor Sanwo-Olu presented as his results in the 1981 WAEC that he sat for, and his name was not found because the name on that result sheet from WAEC has discrepancies with what he presented to the court.
Ahmed, please. Most of these matters are sub judice and are testimonies that are presented in court. We don't want to be fined for contempt of court. Please. Let us allow the court to do their work.
Yes,
right?
I agree with you totally.
Please, Mr.
I totally agree with you. And the reason why I'm bringing... I agree with you totally, and the reason why I'm discussing all of this is because these have become public documents that I have actually had the privilege to see.
Until judgment,
I don't think they are hidden anymore.
Until judgment is delivered by the court, we can't discuss it. Even if it is public document at the moment, we can't discuss the details of papers or documents presented to court, so that we avoid getting into that situation where we run into problem with the court. So yeah, very quickly then, so that we can ask Liborous to expand on it, or let me quickly come back to Liborous, Ahmed. So Liborous, in terms of what we're looking at with this situation, Ahmed just said it's more of an INEC issue when you look at the qualification of people. What is it that INEC need to do to not allow us go through these challenges in courts and tribunals going forward? And what do political parties need to do? Because when somebody is contested first term, and then second term, you're discovering things that should have been sorted during the first term in office.
First and foremost, I must say I like the fact that you had to stop Ahmed from testifying on a matter that had already been testified. And also, I must say that at this stage, those documents are exhibits before the court, and so you can't classify them as public documents. If you are not a party in that matter, you can't even apply for CTC of those exhibits until judgment has been delivered. Then you can now say, okay, yes, you want to apply for documents that were tendered. So at that stage, I think it's too premature to go into the evidence that were, but we can discuss the fact generally. But that said, I don't, it is not an INEC problem, really. I shook my head when Ahmed said that. It is not an INEC problem. It is purely a political party problem and a Nigerian problem. There is nowhere in the law where it says that INEC will have to individually go verifying certificates that were tendered or that were submitted by candidates.
Does it then mean that INEC does not need to do anything? INEC
puts out a form, and that is why they request you to go make a deposition before a commissioner for oath that the information that you're giving is true and that you are not lying on oath. So that's all because if you're putting you're saddling them with another responsibility of individually going to verify, that's a huge fund. And so once they do that, the law now places a responsibility on the candidates of the party that contested with that, the candidate that was declared, or the contestant that, of the party that contested with the candidate in the primaries, to challenge every deposition made so far that they feel is wrong. And it's like you give a notice, and INEC says, well, if you think that this notice it's wrong, it's like somebody wants to get married. Yeah. And they say, if there's anybody here who feel why this person should not get married. So that's the case. It is not for the church, or in this case, INEC, to now go on a voyage of discovering of documents. So if there is anybody within the party who contested, who feels that this information deposed to are not correct, at that point, that person has a right to challenge those information. If you are not a member of the party, you cannot. But if you are a candidate in the election, after the election, you now have a right. It becomes a ground for you to say, I am challenging your qualification. You did not meet the required qualification and you lied on oath. So it becomes a political party problem and a Nigerian problem. So that is why the law empowers those who participated. So at that point, INEC becomes an umpire. Not the one to begin to do verification of certificates. And then also, another very interesting thing, the law also place a responsibility of INEC saying, look, even for qualification, if the man can read and write in your opinion, if he can read and write, if the man says, I remember the case of, I think, Masari. Masari said, well, I have equivalent. I don't have the certificate, but I have its equivalent. The equivalent is I rose from the cadre to become PAMSEC. So, and I have attended enough courses, but primary school leaving certificate, I do not have. So, all of these are equivalent. And so, in the opinion of INEC, that's what the Constitution, that's the responsibility, the enormous powers the Constitution placed on them. And so, when people, I think, like Ahmed has said, what the political parties need to do, because the political party is the beneficiary of any election, and also they are the ones that will suffer because they say the mandate belongs to the party feeds candidate. So they are the ones that will suffer if at the end of the day it is discovered that the documents submitted were either fake or forged. So it is for the political party to do a detailed and thorough verification of every document submitted before they are handed over to INEC. In the absence of that, you might just win an election and it becomes short-lived, because at the point of receiving a crown, or even after receiving the crown, the court says, well, like the case of Degi in Bayelsa State, and so the court had been consistent on that too.
Okay, so first, I would like us to also narrow this conversation to cases that have been decided, so that we'll not, fall in contempt of the law. And I would also like to talk about the general concept. In all of these decisions made thus far, as Africa's Election Petition Tribunal, the ones decided, do you see a pattern? And what do you think informed that pattern?
Yes, two things, two patterns. One is on membership, disqualification on membership of political party. No, three. Second one is disqualification on the ground of primaries, invalidly conducted primaries, lack of notice, proper notice not issued. And then the last one is that age-long Supreme Court decision on the ground that if you have ever forged a certificate before, if I've ever presented a forged document.
Substantive vote counting and vote manipulation matter.
I just told you that one is a tall order. Do you know why? Because if you allege irregularity, Supreme Court, even in the case of Oshoma election, the governorship election in Oshoma, where the question was the documents presented by INEC from the back end, the front end, and all of that. And the court said, no, these are not enough for you to prove irregularity. You must also call the witnesses, or you examine all of the beavers machine. How many beavers are you going to examine within a space of 6 months? So when you have that kind of proving, it's almost above proving beyond reasonable doubts. And so you must prove irregularity polling unit by polling unit. And then also, it must be substantial enough to affect the outcome. That substantiality, it's nowhere defined, it's in the mind.
Who now determines that substantiality?
It is the tribunal that determines the substantiality.
Discretionary.
Yes, so if you say, that's where the Supreme Court also said that a situation where the election was cancelled in one state, Ogun State, for example, that it is not substantial enough to disqualify or to annul the entire election in the entire federation, even though that judgment was 3-2. And so also, substantiality also might depend on the reasoning of the average man on the street. What will the average man on the street see to be substantial? So what lawyers do, at the election petitioners do, is avoid those areas that time will not permit you to prove. So go for the technical areas it will be easier for you, like issue of primaries, where was primaries validly conducted, where all the notices rightly issued, is the candidate qualified to contest, to stand for this election, the documents submitted.
I quickly want to ask you a case. As regards that substantiality in the election itself, can you quickly also, for legal learning, help us review the 2007 Supreme Court's ruling as regards presidential election, that, and I'll come to you, Ahmed, please, I'll still come to you on this. The 07 Election Petition Tribunal, the Yaradua debacle, that was quite close on 4-3. And you remember what was even about that, the crux of the election, the ballot box, where they serialized and things like that. Can you also review that and juxtapose that?
That's why I'm saying that at the end of the day, the Supreme Court also still didn't annul that election because on the issue of substantiality and then INEC guidelines, if I remember. So, and that's why I'm telling you that against all of those knowledge and information, why would you want to go on a voyage you know that you require more than 6 months to prove? In the case of Peter Obi in Anambra State, it took them almost 3 years. It took them almost 3 years. They called almost 300 and something witnesses. But in this case here, you don't have the luxury of having to call more than, or not even up to 100 witnesses. One of the matters I did in Abia State, 6 local governments, the petitioner called about 29 witnesses. And the court says those witnesses were still not substantial enough in a senatorial district where you have almost 100 and something polling unit. So, in the case of Yaradua also, the petitioner talked about serialization of ballot boxes, ballot papers, and irregularities in the outcome. But irregularities is not as a matter of claim. It takes proof. Have you been able to establish? And as a lawyer, I wouldn't want to even bother myself talking about irregularities in all the election. I would rather go to the narrow area of, is this candidate qualified?
Okay. Let's ask, Ahmed, please, have you seen any patterns?
Can you say that again, please?
I said, have you seen any patterns as regards the case that are judged? Let's limit ourselves to the case that have been judged already. Can you see any patterns?
Yes, of course. I'm glad with the way Liborous has actually highlighted the issues. You know, for people who are pushing to courts on grounds of irregularities around the ballot boxes, or we're not allowed to vote, lines were being shot down, ballot boxes were being snatched, we were chased out of our lines and all of that. You know, those are going to be very, very hard to prove in court, which is why smart lawyers and smart legal teams and smart candidates of elections actually go for the jugular, which is, of course, to ask if there's validity in that person's ability to contest for that election. And I think you did ask a very pertinent question earlier, which is, why do we keep seeing the recurrences of these kind of issues around election matters? I think it's consequences. I think because there are no consequences for this kind of mishaps, because if you do pick up your pen and sign under oath that the information that you have provided before the commission is true and to the best of your knowledge, and then we come back to find out that they were not true, it means that, and then you still go on and you go on the street, and then police doesn't talk to you, doesn't pick you up, and police says things like, we haven't been called to the matter. It's the same case with me bringing up documents that are flying around that I've seen as certified true copies, which I have been told not to speak about anymore, to say very clearly that when the court actually passes a judgment, for example, on an individual who has presented fake documents, it is expected that that individual is being asked to visit the police and, you know, clearly state why he had to swear under oath before a document that it presented to the commission, to the Nigerian people. And I think the Nigerian people also must rise up at a time like this and ask those very deep questions as to why you waste our time, why you waste our resources, why we would have to go around campaigning for you, knowing fully well that the process that is supposed to bring you on the sponsorship level to contest for an election that we have all believed would bring us succor, was even flawed in the first place. So I think these things are important, and I think Nigerians would have to sit up and ask these very deep questions and allow sentiments and emotions to be thrown out of the window while we focus on the facts.
All right, we have just a few more minutes to go before we end, but I'd like to ask maybe perhaps both of you, starting with Mr. Buhari and then going to Mr. Oshoma with regards to consequences. Very valid point with regards to the fact that even when these matters are thrown out of court on basis of fake documents and the likes, What are the consequences, or what should be the consequence following that? Very quickly, Mr. Buhari.
Again, I'm not a lawyer, and I've been asked not to manage my comments because of the legality involved in all of these matters. But I think it's a matter of the court, it's a matter of the system, and these things have got to be spelled out very clearly so that people do not repeat these things. But again, it's important for members of political parties to even ask this question. So I think the problem is still with INEC. INEC cannot be exempted from this matter. It's not just an umpire, it's also subjected to the Nigerian people with regards to how we want them to conduct these exercises. The political parties are involved, the individuals are involved, and the Nigerian people must ask those very deep questions, because this is our time that is being wasted.
All right, thank you. The lawyer in the house.
Yeah, quickly, when we talk about this presentation of documents, we should also understand that these documents are classified in various categories. It is not in all cases that the documents are forged, but sometimes discrepancies can even lead to disqualification. You remember the case of Degi. Yeah. It was discrepancies, and then the Supreme Court came up with a novel pronouncement that it ought to have been a deed of pool and not an affidavit. So in such case, you don't ask the person to go visit the police, but a situation where the document presented was clearly forged, that becomes a criminal matter.
Yes.
And once that happened, the consequences is that, the police should take up investigation, which we hardly see here. And then also, the major consequence for the political party is that at the end of the day, they gambled on a forged document, and then they are denied, access to the votes.
All right, I think that's something we need to perhaps magnify a lot more with regards to, let it not just be that you lose the case at the election petition tribunal, but that there's a follow-up if it's a criminal infraction. Well, thank you very much for your time today, Mr. Ahmed Buhari, and of course, Mr. Liborous Oshoma.